In this lecture, we would like to discuss about flexible and rigid constitutions. So, in this regard, Lord Bryce, in his studies in history and jurisprudence, expressed the very classification on the basis of method of amendment. Bryce made this classification. So, accordingly, a flexible constitution is one that can be amended without the help of any special procedure. On the other hand, without a constitution is called rigid if it requires special procedure for its amendment. The Constitution of England or United Kingdom is usually referred to as being representative of the flexible type. Also, the Indian Constitution, while the Constitution of United States of America, Australia, Switzerland are cited as examples of rigid type. So also Professor Strong in his modern political constitutions express that whether the process of constitutional law making is or is not identical with the process of ordinary lawmaking. The flexible constitution does not make any distinction between these two processes in the sense that both constitutional law and ordinary law are enacted in the same way. But in case of rigid constitution, it makes a clear distinction between the two processes by providing for constitutional lawmaking a procedure different from that followed in ordinary lawmaking. For example, as it is provided by Professor Jennings in his Law and the Constitution, that in England the Constitution is flexible as no distinction is made between the procedure for constitutional lawmaking and that for ordinary lawmaking. Hence, strictly speaking, there is no constitutional law at all in Great Britain, as Professor Ivor Jennings wrote in his book The Law and the Constitution. So, in that regard, we would like to discuss certain strength of flexible constitution, and regarding those strength of flexible constitution, it is elastic in nature and also adaptable to every situation, and it also puts off any kind of revolution, and also it would make possible for social and political change. So flexible constitution has already observed make no distinction between constitutional law and ordinary law. So constitutions embodied the totality of social forces. So law are altered. Such constitutions became elastic and adaptable. The constant the constantly changing social situation rendering existing legal principles obsolete and demand reorientation as it was presented by the ancient Greek political philosopher Heraclitus, who expressed that society is always like a river, water is in a state of flux, so it is also having easy adaptability. So a flexible constitution also puts up the day of revolution. It acts as a great shock observer in moments of crisis when an immobile constitution fails to satisfy the crying needs of fast moving society. The malleability of a flexible constitution not only removes the temptation to disregard the constitution but also affords a legal mean of satisfying popular passion and of minimizing or preventing revolutions by meeting them halfway, as it was expressed by Professor Garner in his wrote work, that is political science and government. So also in flexible constitution we found it is as an assets which works for social and political change. It defeats the very human ingenuity to frame a so-called perfect constitution. So, constitutions will hold good for all time to come if it would meet all kinds of social and political changes. And now we'll discuss certain weaknesses of the flexible constitution. So, among the weaknesses we found instability and lack of performance. It fails to evoke popular respect for the constitution, and it failed to safeguard the fundamental rights. So, as we found, the very flexible constitution is known for its easy process of amendment. So, it's supposed to be suffering from instability and lack of permanence. So also, such a constitution is apt to be a plaything of statesmen and politicians. Popular passions might be roused to bring about changes in the fundamental laws. So, the very flexible constitution, in absence of any distinction between fundamental constitutional laws and ordinary laws, may fail to evoke popular respect for it. Moreover, the flexible constitution has been criticized as being unsuitable for safeguarding the fundamental rights of the people and the very interest of the minorities. So, Professor Casey, where as expressed constitution which is easily alterable by a numerical popular majority may so threaten or destroy the rights of a minority that it provokes the minority to justifiable disobedience. So now we'll discuss the very strength of rigid constitution. And rigid constitution is having its stability, steadiness, and permanence also. It evokes popular respect for the constitution. So also it secures the fundamental rights of the citizens. So the rigid constitution as its very strength we found the rigid constitution having special process of its amendment possess the virtues of stability, steadiness, and permanence. It cannot be easily changed by the whims of a popular majority or by a sudden gust of popular passion. As a body of superior fundamental laws, the rigid constitution usually evokes popular respect for it. In fact, it inculcates in the people living under in a constitutional conscience also the fundamental rights of the people and the interest of the minorities are more secured under a rigid constitution. Thus, a federal constitution, as Professor A.V. Dicey re- remarked, seeks to make a reconciliation between national unity and power and state rights is probably we found in a rigid constitution. So now we'll discuss the very weaknesses and the weaknesses of the rigid constitution. It is an obstacle to social change and also it breed conservatism. So as Professor Lasky expressed that it will always reflect the spirit of the time at which it was made. Hence, the legal principles adopted at a particular time are with passage of time sure to be somewhat out of date and obsolete. So, it creates an obstacle to social and political change as it requires every constitution requires adoption to changing social situation. So also Lord Macaulay observed that the great cause of revolutions in this world that whole nations move onward, but constitution stands still, as it was quoted by Professor Gardner in his book, The Theory of Political Science and Government. So, again, we found as Professor Harman Finer observed the closer the democratic constitutions gets to being a milestone around the necks of a growing society, the more violent the impulses against frustration. So a rigid constitution like that of United States of America, which left to the custody of a judiciary, is definitely to breed conservatism. Conservatism. So there the judges have been empowered to pronounce upon the constitutionality of laws on the ground of their reasonableness. Such a provision may give an undue premium of the private prejudice of a particular member of the judiciary which is conservative. So, Professor Hadalaski, in his grammar of politics, expressed that it must not be forgotten that such legislation held unconstitutional by the Supreme Court is in fact so held not upon the principle of strict legal theory, but upon a view of what is reasonable. The substance of reasonableness does not dwell in the clouds, but is built almost entirely upon the habits and contacts of those estimating it. So, now we'll discuss the very growth of constitution. So, in that regard, we would like to discuss the formal growth and also the informal growth of constitutions. So, as regarding formal growth, we found constitutional amendment, judicial review, statutes, conventions, treaties, and ordinances are considered as the formal growth. So, in that connection, as we found Article 5 or Article 5th of the American Constitution provides that amendment of the Constitution may be made if the proposal is passed by a two-thirds majority in each house of Congress and is thereafter accepted by the legislatures of three-quarters of the provincial states. Similarly, we found under Indian Constitution Article 368 provide in one part that the Constitution can be amended by a majority of at least two-thirds of those who sit and vote and an absolute majority of the total membership of the parliament only. And for amending the provisions in the second part, within which division of powers between the center and the states is included, in addition to the majorities prescribed above, at least half of the states or provinces should also agree to such amendment. And similar amending provisions are to be found in almost all the constitutions in the world. And as regarding the second formal factor responsible for the growth of constitution is judicial review, and the very idea and concept of judicial review is an innovation of the Supreme Court Chief Justice of America, Justice Marshall, in his famous case of Marbury versus Madison in the year of 1803, and so also in many other such important cases, such as McClock versus Maryland, Gibbons versus Houston versus East and West Texas Railway Company versus United States. So, they laid down those judicial principles and judicial innovations which laid the foundation even stronger for constitutional law and for the growth of constitutional law. In the same way, in India, Article 32 of the Constitution of India and also Articles 131 to 136 expressly vest this judicial review power in the Supreme Court, and it would further emphasized on the provisions and how it played a considerable role in regarding justifying the scope and jurisdiction of Article 13 and limiting the power of Union Parliament and Union Executive by laying down rules, regulations, and also fundamental laws which it held as the basic structure of the Constitution. So, in this way, it led to the formal growth of Constitution. So, also we found there are many statutes. So, all statutory provisions and statutes also fill in details of the Constitution, and those processes automatically leads to an expansion of the Constitution. So also the customs and conventions have the effect of turning written law into quite different courses. They may even render the laws inoperative. So, to quote Professor K.C. Ware, why urge and convention, the law of a constitution, strictly so called, is supplemented by a whole collection of rules which, though not part of the law, are accepted as binding and which regulate political institutions in a country and clearly form part of the system of government. So, in that connection, he made an reference to the very importance of customs and conventions which constitutes the very British Constitution, to be found in almost in all countries the same kind of contribution of customs and convention. So also treaties and those ordinances issued by the head of the state, the executive, are also responsible for the formal growth of Constitution. So, treaties entered by a government or by the union government as being ratified by the union legislature becomes a part of the formal law of the land. So it becomes a part of the Constitution. So also the ordinances issued by the President of India in case of India and the governors of a state in case of India. So also ordinances issued by other heads of states in other different countries are also become part of the formal law of the land. So these are the formal factors for the formal growth of a constitution. And regarding the informal growth of the constitution, we found growth of centralization of power. So it has provided that the state, this is to assume certain immutable principles of law as fixed principles of reason in accordance with such a community has agreed to govern itself. There is a tendency on the part of social conditions to outspace the rigid laws. In such circumstances, if the fundamental law fails to keep pace with the social movement, revolutions breaks out to restore unity between the social contradictions and the legal principles. So, as such, to bring out the problem of constitutional growth, this is what we found as regards to the concentration of power. So, in particular, as we found the informal growth, so this is the growth in centralization of power, and which resulted in the formal constitutional amendments also. The very operation of the party system and the electoral system. So also the attitude of the people and ignorance and indifference of the people and monopolization of power or the other informal factors or changes which affected the informal growth of constitution. So by operation of the party system and the electoral system and the attitude of the people towards the constitution, most constitutions do not refer specifically to parties. In spite of that, we found the very constitution of the then Union of Soviet Socialist Republic and even the present, the Chinese Republic. It is the operation of the Communist Party which determines in the fundamental growth of constitution in the Chinese countries and also as it was in the former Union of Soviet Socialist Republic. So also, the very working of a constitution is greatly influenced by the prevalent electoral system, the methods of voting, the qualification of voters, the distribution of seats, all these details of the electoral system determine the composition of the parties and the strength of the executive in the legislature. Still, however, in most countries, these are developed with the help of ordinary laws and without formal constitutional amendments. And so also, we found that the attitude of the people towards the constitution also influence its operation, as we have to mention here one important statement made by the first President of United States of America, President George Washington, said in his farewell address that Time and habit are at least as necessary to fix the true character of governments as of other human institutions. In old and settled communities, the people come to develop a habit of obedience to the Constitution. It is treated with great respect, and such an attitude acts as a force to preserve the Constitution against light-hearted attempts to change it. And so other countries were owing either to the ignorance and indifference of the people or to the monopolization of power by a particular group. The constitutions are easily changed both formally and informally. So, in that case, we could cite that the republics of Central and South America frolic and with their constitution, taking the advantage of popular ignorance and indifferences. And same was happened in the former Union of Soviet Socialist Republic. The constitution is what the Communist Party says it should be. Same we found also in France and Italy. There are parties that condemn the whole system established by the Constitution. Such a total attack on the constitutional system makes any amendment impossible for the parties desire to bring into existence a wholly different setup. So, in such a case, as Professor Casey Ware expressed that reform may be postponed for too long. For too long, it may make revolution inevitable. So, these are the informal and formal factors regarding the growth of constitution. So, in this lecture, we have completed about the constitutions such as written and unwritten constitution, flexible and rigid constitutions, their respective strengths and weaknesses. So also the very growth of constitution and constitutional system in two different ways. One is the formal growth of constitutions, and the second one is the informal growth of constitutions. So, we have completed our lecture on another important legal and political concept, and that is constitution.